Hello, I'm Marielle Gauthier, a certified executive and personal coach. Welcome to the Power Up Your Retirement Lifestyle program, and welcome to our new estate planning series. In this three-part series, we're going to cover the last will and testament, the power of attorney, and the healthcare directive. In today's program, we're going to focus on the last will and testament, more commonly referred to as the will. A will is a very important document required as part of your estate planning. Do you have one? If you do, when did you last update it? Today our guest is going to explain the importance of having a will, what we need to do to create a will, and different scenarios that could impact your last wishes. Elizabeth Williamson is a lawyer in Saskatoon, Saskatchewan. She has a general practice focusing on wills, estates, residential real estate, small business, and governance. Elizabeth enjoys helping her clients plan for the succession. She believes a valuable gift that we can all leave is an organized estate. Welcome, Elizabeth. I certainly agree with you, right? If we might not have our office organized, but at least let's have our estate organized, right? So let's just jump right in. Wills. Does everybody need a will? And if yes, why?
Right. So it's highly recommended that everyone have a will. And I would say, in particular, if you have children, if you have significant wealth, or actually if you're over 30, you should have a will. There's a number of reasons. If you die without a will, then there's an act in every province and state in the US that will govern as to how your assets are divided. In Saskatchewan, it's the Intestate Succession Act, and it follows a formula, and so you don't really have much say you wouldn't have any say in how your assets are being divided. So if you want to have a say into how things are divided after you pass away, you need a will. The second reason is to name guardians for your children. Another reason, you can do some tax planning, and that can save you significant money in taxes if you arrange your estate, depending on what your estate consists of, but if you arrange your estate in a tax smart way. And a really important reason is it's far easier for your family if you leave a will than if you don't. The process, you have to involve the courts more, you have to figure out who's going to be the administrator. It's just a lot of work.
So if somebody dies without a will, or let's talk about first when you die with a will. What happens? Like what's the process?
Right. So the answer most lawyers will give to most questions is it depends, because it will depend on the facts. If you have an estate that's worth more than around $35,000, you will need to probate your will. Because the bank or the investment company or whomever holds the asset will not distribute the asset to your executor unless the will is probated. And probating a will is a legal process. So you hire a lawyer to assist you, and what is happening when you probate a will is the court is saying, yes, this is the final will of this individual, and the executor, the named person, is the person who has the authority to manage this. So any company who wants to pay the amount to the executor, go ahead and do it. That's what probating a will do. And you need to collect information about all the different assets that the deceased had at the point of death, and the documents get submitted to the court. You don't have to go to the court, it's not a trial or anything, but then after that's done, you get a letters of probate, and then you can proceed from there.
Okay. So essentially saying, yes, this person is deceased, and this person or the executor or executors, they are for sure valid, and these are the folks that they're going to take charge of the estate.
That's exactly
okay.
it. Yeah.
So if someone, as you were saying earlier, that everybody needs a will, if somebody dies without a will, then is that a different process?
Yes. So what is happening is you apply to the court, a person who thinks that they should be the administrator, And again, there's an act in Saskatchewan here that says who the first person in priority that should be, and then it goes through that list. So, it would be your spouse, and then it goes from there. And you go to the court and you apply to be named as the administrator, and you go for letters of administration. And then once that is given, it authorizes the administrator to have a similar role as the executor would have, if under a real will.
But then that administrator has to follow the act, and it's like there is a, what's that called, like a...
Yeah, there's a formula as to how much goes to whom.
I see. Okay. All right. So let's talk a little bit about, we need a will. I mean, obviously, we can go and hire a lawyer to help us do that. I've seen these will kits, at the local bookstore. I've seen them online. Would you recommend those?
Right. So, first I'll answer your question and then I'll tell the reason why. Yes, you can fill out a will form, and as long as you get it witnessed properly and you sign it properly, it can be your official will. However, I recommend against that. So in Saskatchewan, there are two different types of wills that you can have. You can have a holograph will, and that's when someone writes out on a piece of paper in their own handwriting. The entirety of the document has to be in their handwriting, and it's dated and signed, and it says where you want your estate to go. That's a holograph will. It does not have to be witnessed. If you have any other kind of will, so that's a typewritten will or a will form where you filled in the blanks, that type of will needs to be witnessed. It needs to be witnessed by two individuals, and they have to be present at the same time. They have to witness you signing or your acclamation that that is your signature, and it needs to be done properly. Secondly, you may not fully understand the legal terminology that might be used in this will form, or how your assets will be divided, what actually flows through the will, what doesn't, and there's a lot of matters that you may not be aware of. So it surprises lawyers pretty regularly when people have an estate that's worth multiple hundreds of thousands of dollars, and they end up spending less than $100 for a will kit, and they believe that that's a good investment to deal with how their whole estate goes. Some litigators are now believing that will kits are great for them because it just makes legal battles, and the will that results ends up getting dragged through the courts because it either doesn't take into consideration all the assets, doesn't treat the people properly, or it's just too confusing. So I highly recommend against it. You can have a will drafted here in Saskatchewan, a single will for probably less than $500, or a couple's will for probably less than $1,000. It depends on how complicated your situation is, but that is not that much if you're dealing with $100,000 estate or more.
That's right. And in the grand scheme of things, right?
Yeah.
It isn't much money.
Yeah.
Yeah. No,
and it'll save you a lot of money.
Yeah.
Or sorry, it'll save your estate a lot of money.
Yeah.
Getting it right the first time.
Yeah. No. For me personally, I'd rather have a lawyer do it because I may forget something, right? Like hopefully they have a checklist and say, well, what have you got this for? If you got land or buildings or the cottage, and all, which I don't, but nice to dream. But there's some, we don't know the laws, right? So I'd rather, because it's there's enough going on when somebody dies that it's nice to, as you said it, and when I introduce you, it's nice to have an organized estate.
Yes.
It's a big gift that we give. Okay, so that answers that. So let's just talk a little bit about some scenarios. And I know, my gosh, we're only, looking at the tip of the iceberg. There'll be all kinds of scenarios. But let's just say that, I have some children, and I have a second husband. But I want my house to be inherited by my kids, but not by my second husband or his children. So I want it to go to my biological children.
Yes, so you can do that. There are a couple of requirements to be able to do that. So in Saskatchewan, the law says that your spouse has a legal right to part of your estate. It's similar to if you're getting divorced, your spouse has a legal right to part of your estate. So if your new spouse and you are living in the house that you want inherited by someone else, it's highly recommended that you have an interspousal agreement that specifically is signed by both spouses that says that sets out how you want your assets to be divided, and then you want your will to align with that, so you don't have your interspousal agreement saying something different from your will.
So that agreement says, so let's say my husband is Joe and I talk, and I say, Joe, I really want the kids to inherit the house.
Right.
And Joe, if Joe's in agreement, then is that the interspousal?
Yeah.
Okay.
Yeah.
So it's really an agreeing to.
It's an agreement to divide the house differently than what the law would generally require for a matrimonial home.
Okay.
A matrimonial home is the home where you live with your spouse.
Okay, good. So second scenario, let's say I'm concerned about my daughter's marriage. They are having some problems. But in my will, I'm leaving her a lot of money, like maybe half of her inheritance. Or yes, I'm leaving her my estate. But I don't want her spouse to get, part of that. Like can I protect my own estate from that, but still providing for her?
Yes, you can. So again, in Saskatchewan, different provinces in Canada really vary on this one, but in Saskatchewan, if you're married and you receive your inheritance while you're married, your inheritance is considered family property. And if you get divorced, your spouse or ex-spouse is eligible to claim half of your inheritance. So if you don't want it to go that way, you specifically have to have let's say in your circumstance, it's your will and you're leaving it to your daughter. You would have to draft your will appropriately. There should be a clause in it, either that says, I'm leaving this estate to the named individuals and I do not want it divided amongst them and their ex-spouse. And in that situation, if your daughter receives the inheritance and keeps it in a separate account, doesn't mingle it in the joint account, doesn't use it to buy a house, the family property, there's a good chance that her inheritance will be seen as only her property. It's not a slam dunk though. So if you want a clause that makes it absolutely effective, airtight, what you need to do is say that you are leaving this to your daughter, but to be able to inherit, she needs to have an interspousal agreement with her husband that says that she will inherit it, and he will not have a claim to it. And in that situation, then she'll inherit it, it won't be a problem. The clause goes on to say if she doesn't have this agreement with her husband, the money will be held in trust, and it will be paid to her for her use. It'll be managed by the executor of the estate or some other named person, and it will stay that way until she does have an interspousal agreement with her partner, or until they get divorced, or until she passes away. So that is the airtight method to make sure that her inheritance is going to her and not being split between her and an ex-partner.
Very interesting. Okay. So here's another scenario. We'll say that your spouse has died a number of years ago, but now you have a new partner, and planning on moving in together. So do my kids? Let's say I'm one of those partners. Do my kids? Do they inherit everything?
Right. So in Saskatchewan, when you have lived together in a spousal type of a relationship, even if you're not married, if you live together for 2 years, the other person is considered your spouse, and they begin to have rights to your property, similar to if you were married. So again, as we spoke of earlier, if you don't leave anything to them in your will, they can make a claim against your will for a portion that they should inherit. And some people who are moving in with partners don't realize that common law partners end up having a lot of the same rights as a married spouse. So you should consider rewriting your will, or at least having it reviewed if you are planning to move in with your partner, or if you've lived together for 2 years. Also, if you and your partner have a child, that time limit is reduced to 1 year. So if you've lived together and you've both had a child together, you become a spouse after 1 year. So you just have to be aware of that.
Okay. I don't know if this is maybe off topic a little bit, but I just thought about, like a couple moving in together sometimes, or even before they get married, they have they develop a prenup. Now, is that a Canadian or an American thing, or?
So a prenuptial agreement is what we refer to here in Saskatchewan as an interspousal agreement. It's the same thing. We can call it a prenuptial agreement. It's just that the act here in Saskatchewan, the Family Property Act, refers to them as interspousal agreements.
Okay. Oh, okay. I see.
And there's certain things that need to be done with an interspousal agreement. Both spouses signing it need to get independent legal advice, and you have to sign independent legal advice certificates about it. So there are some requirements to make sure that it is an interspousal agreement.
Okay. Lots of food for thought there.
Yes.
My gosh.
Yeah.
So one more scenario for you. Let me see. And we'll just say this is a scenario. So maybe I want my spouse to inherit everything, and that's what the will says, or my will says. So can I just have my RRSPs and my TFSAs go to my estate, or do I need to specifically name my spouse as the beneficiary of my RRSP and TFSAs?
Okay. So here in Saskatchewan, your RRSP and your TFSA, so Registered Retirement Savings Plan and Tax-Free Savings Account, are registered savings. And there are specific provisions that govern how they're dealt with. So if you designate someone as your beneficiary of of those assets, they will go directly to that person. They will not flow through the will. And what that means is you don't have to pay probate fees on them, and the legal fees that your estate is paying are often based on the amount of money of the value of the assets flowing through your estate, and so your legal fees will be less as well. So there is a savings. Probate fees in Saskatchewan are $7 per $1,000 value of your estate. So you're saving an amount there. Plus, it's much faster and immediate and simpler for those monies to be transferred directly to you. You don't have to have the will probated often. They'll just come directly to the designated beneficiary. So that's great. If you don't designate anyone, it will go to your estate, and then it'll if you have a will, it'll go as your will has said. And if you don't have a will, then it'll go according to the Intestate Succession Act, again, as we referred to earlier, according to that formula in the Act.
All right. Wow. Well, I think we'll stop here. I mean, you gave us a lot of great information, really a lot of neat little scenarios too. I mean, from my own personal perspective, what I've heard you say is, I think it's best that there's good communication between, you are, the couple,
Yes.
and it's also been my experience, I think, to be able to talk openly to your family about your will, because I've heard, horror stories, and that's a different video altogether.
I just want to leave you with 2 comments that you've just reminded me of.
Okay.
One is, I totally agree, one of the most important things is communication with your family, and often communicating with your beneficiaries all together in one room, so everyone hears the same thing. The other thing that's really important, we've talked a lot about couples, single people, it's even more important that they have wills, because often who they want their assets left to is usually someone quite different than what the Intestate Succession Act would declare. And it just makes it far better if you have a will.
Perfect. Good. Excellent. Well, thank you so much, Elizabeth. There's a lot of food for thought there. And I just think it's just so important to have that will as part of your estate planning.
It's my pleasure.
Thank you very much. So I would love to hear from all of you who have watched this video. Tell me a little bit about what did you like about what you heard? What stood out for you? How will this information help you prepare for your own retirement, or at this point, just, what are you going to do? Even if you're not that close to retirement, has it spurred you on to develop your own will? And what are you going to start doing now? So please leave me your comments on these questions in our community Facebook page. And in closing, keep on thinking about what you want and how you want to live the second half of your life. Thanks for watching, and I look forward to seeing you again soon. I'm Marielle Gauthier with Redworks Coaching. Have fun creating your extraordinary life.